Coca-Cola would do that. Got it. Right. So why is intellectual property so important? Number of reasons. For me, anyway, the primary reason is that it encourages creators or, creatives or innovators to actually keep doing this, at least in the beginning stages, it can be, what do you call it? A thankless endeavor. Why am I writing this song? Why am I trying to come up with this invention? If I know that I'm going to put all this effort and possibly money into producing this music or producing this film and nothing is going to come back to me, or anyone can just carry it and go away, what's the point? And to be honest, I think there are very few people who have the means or the motivation to be able to continue creating and innovating without the motivation that this protection that without the protection without the motivation that the protection of intellectual property offers, right? So with IP, you get legal protection, you get ownership, it encourages innovation and creativity. Strong one is that it encourages economic growth and market advantage, right? A huge thing that the US, that China, let's talk about China, have is that they have a huge, like a very strong intellectual property portfolio. When you look at the patents that have come out of these countries, when you look at the various technologies, the various creations, whether entertainment or otherwise, that have come out of these countries, they had a strong, they had the what do you call it, forward thinking, to start protecting them and to start creating them and strategically using this intellectual property that they own to build their countries, to build their economies. And so moving on to the next point, which is incentive for investment and funding, what we're now seeing a lot in Nigeria is that these foreign companies, foreign countries even, are looking into Nigeria for investing, and they're investing into our intellectual property. They're investing, this comes as no surprise to anyone, into our entertainment industry. We're seeing a lot of co-productions in film and in music, even in our technologies, we're, slowly, gaining ground there. There's been a lot of interest and, sparkles around the startups and, the technologies that we are founding in-house in this country, and so it's a huge and very, very excellent way for us to boost our economy. Then technological advancements and knowledge sharing. If I come up with something and I just think about it and I keep on thinking about it and I just keep it inside my head, I'm not helping anybody. I'm barely even helping myself, So when we share this information, we're all able to grow. And when we look at some places in the world that have no exposure whatsoever to other countries, other cultures, you can see where they are, in terms of their infrastructure and all of that, like, even think about it, right? How their houses are made, they're maybe just made from like bamboo, or they're made from mud and that kind of thing. Yeah, those kinds of materials, as opposed to iron on all these structures and what do you call it, skyscrapers and so on and so forth, but that comes from the exposure that we get, when we, one, share our thoughts, when we share our innovation, we share our creativity with others, and when we have the opportunity, likewise, to see these ideas, in a physical form. Okay, international expansion and trade, preservation of cultural and artistic heritage, consumer trust and brand recognition. I said it earlier, particularly with regards to trademarks. It's for the benefit of the consumer at the end of the day. I want to know what I'm getting. And I also don't want to be cheated, right? I don't want to be cheated into paying an exorbitant amount for something that is basic, you know? So I don't want to go over information that you already have, but you know, with trademarks, an important fact to bear in mind is whether or not that particular mark has become generic, right? Once it's associated with something that, you know, like, okay, as an example, this is a bottle. If I tried to trademark the name bottle, it wouldn't work because what else is anyone else going to call it, you know? So if I now create another bottle and I want to use the word bottle to describe it, am I going to get hit with a lawsuit, a trademark related, you know, infringement lawsuit, you know? And so the law also seeks to prevent people from unduly, you know, restricting these uses while also protecting the consumer. Right, so how am I doing for time? Sorry,
Okay,
you're
you still have
muted.
time.
Okay, all
Yeah,
right,
you
I'll
still
keep going then.
have time.
All right, so I'll move on to maximizing our intellectual property value and monetization. So on this, I'm going to talk about the licensing and commercializing of IP, as well as IP portfolio management. IP portfolio management is a bit convoluted, so let's see how we go anyway. If hopefully I have enough time to get into that, but I'll start with the licensing and commercializing. So this is a very practical area of intellectual property practice. All of us know about you know, registration of copyrights, registration of trademarks, patents, etc. Right? But what do you do when you're in front of a client who is not just about having, it's one thing to register the trademark, register the copyright, the patent, whatever the case may be. Another thing to actually use it, for it to, you know, bring you money, for it to go out into the world, right? So how do we do it? And also importantly, how do we do it in such a way that we protect ourselves and it's effective, right? So with creative works, you're looking at licensing, you know, and what a license essentially is you're giving whomever permission to use your work for a period of time in a particular area, and essentially you're giving them the rights, the exclusive rights that you have. So copyrights gives the author of a copyright exclusive rights to adapt it, to distribute, to reproduce, etc., etc. So when you grant a license, you're giving them a particular right, whether, you know, you're giving it to that person exclusively, as in you're the only person who now has this right to do it, or you're doing it in a non-exclusive manner where, you know, you can parse it out and give it to multiple people. But basically, you're saying to them, I have this exclusive right, but I'm willing to share it. Similarly with patents, the amazing thing about patents is that you have a monopoly on whatever it is that you created for a period of time, right? And so with that, you basically buy yourself time to build up your brand, so that by the time the time runs out, people are already so used to your brand, they already trust it, that you would be the go-to person, you know? And even if you aren't, you've already made a lot of money from that, so it's okay if other players want to join in, right? And so this is particularly true when it comes to pharmaceuticals. On the other hand, what patents do is that it gives, you can also license your patents. So I own this patent, I've created this thing, but you know what? I'm not going to hold on to it, or I'm not even interested in, you know, manufacturing it and, you know, putting it to market. But hey, I can license this to you. I can give you this license and you can go out and produce this thing and start selling it. But you give me, you know, you have to pay for that license. So there are various ways to go about it. So what do you need to think about when you are licensing your creative works? You need to define every term clearly. Go straight to the point, and make sure that particular, I'm going to just state them, but like, these particular terms have to be stated. How long it's going to be, what rights in particular you are granting them. Like I said, as a copyright owner, you have the rights to distribute, to reproduce it, to, so on and so forth. So you're actually going to tell them, this is the rights that I am giving you. Do not step out. Okay, stay in your lane, right? So specify what rights are being granted. Are there any limitations to to those rights? They can distribute it, but they can only distribute it within a particular area, for example. How long do they have that right for? And then you want to talk about how much they're going to pay you for you granting them this right. And then, before you even go into that sort of conversation, to be honest, you need to understand what your work's value is. We have a lot of clients who ask us, like, how much should I charge for this? And I'll be honest with you, my first answer is, like, what do you want to charge? At the end of the day, there's no point in you putting this stuff out there and then you feel cheated. No one wants to feel cheated. You don't want to feel like your clients rather, won't want to feel like their work is being undervalued, but you have to marry that with wisdom. You have to marry that with what your negotiating power is, and with what the market is saying, right? So you'll assess the value of your work based on how unique it is, what the market's demand for it is, the potential for revenue generation, and then this will help you to set the right fees. And then yeah, I said it before, but you want to state whether they have an exclusive license or whether it's a non-exclusive. This will determine also the price that you're giving them. If it's going to be an exclusive license, then I'm going to charge top dollar for it or top naira for it, as opposed to if it were a non-exclusive right that I'm granted. That said, if I am huge, for instance, in the music industry, then regardless of who I'm giving this rights to, whether it's non-exclusive or not, I can charge a lot of money for it by virtue of the brand that I have built, right? So in a lot of cases, you're going to see multiple intellectual property rights at play in determining what that value is, and just to add on the importance of branding. Actually, I think I've said it already, but yes, importance of branding. I can't say it enough, but the brand that you build, or the brand that you build, which is your trademark, can boost up your other intellectual property assets. So don't let any of them falter. Don't think that any are not important. They're all important. And what we have to do as lawyers is to look at, to gather all of these IP assets together and what you call it, put it in a comprehensive list and value it, right? And come up with some sort of strategy for how we can piggyback off of one in order to get the best out of another. Continuing on, you want to talk about money. You'll talk about territory, duration, limitations, restrictions. You want to think about promotion and marketing. Yes, I'm giving you a license to distribute, but then do I have to do all the marketing, or are you going to handle the marketing? You want to have those conversations with the other side. And then build relationships with your licensees because they might be repeat customers. Okay, for patented inventions, you're going to, if you're licensing it, you're going to license the patents to third parties and allow them to use, make, sell, or distribute. I said this earlier, so you have the patents and maybe you don't want to do it yourself, manufacture, etc. And so you hand it over to, or you license it to someone else and give them that option to to create it, to manufacture and to make money. But in exchange for that license, you're going to get your money. And then you can also sell it. I created this. It's amazing. Oh, you want it? Here you go. But pay me. So you essentially assign it completely. You sell it as if it were a piece of land, and you part ways with it in exchange for a nice chunk of change, right? You could also do joint ventures and partnerships. I created this thing, but maybe you have the wherewithal to actually do the manufacturing. So let's join forces. My contribution to this thing is my intellectual property. Your contribution is perhaps your expertise in this area or your money, and then we all make money. So I think all of us like money, and I keep on saying money, 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 but bottom line is we're talking about how to make money from your intellectual property. Okay. But yes, anyway, you can create a startup. That's going on a lot right now. Technology transfer offices, a lot of universities want this. And so you can partner with them or collaborate with them in order to do this. You can create a subscription or service model. There are multiple ways that you can leverage on the intellectual property that you have in a patent in order to make money. So intellectual property portfolio management, right? This involves strategically organizing and overseeing your IP assets and basically setting them up for success, for lack of a better term. So we usually think of portfolio management in terms of like finance or investments, right? When you invest in various companies. But when we're talking about IP portfolio management, you might look at a particular country, you might look at a particular company, you might look at a particular individual, depending on who your client is, right? And say, okay, what do you own? And how can we use this to either create something, build something, or just, leverage on it for finance. All right. So a well-managed IP portfolio maximizes the value and potential revenue streams associated with the IP assets. And if it's managed effectively, it ensures that the IP assets are appropriately leveraged, enforced, maintained, and they support the innovation, competitive, and business growth of the company or the individual. Basically just support their goals, their financial goals, and other goals. So what's the process? We acquire either by creating it or by purchasing it. You protect it, make sure that everything is registered, everything is locked down, any agreements that need to be drafted and signed are signed. And then once we have all of that, we look at it, we can evaluate it. This is at the point where we've gathered all of this, and this evaluation is a constant process. You always have to look back, because at the end of the day, just as with real estate or real property, everything is always moving, right? So, and likewise with your IP assets, you want to see what exactly is the market saying for this right now, and make sure you're moving with it. And then you want to, so why do we evaluate it? So that we can utilize it effectively. All right. Then there are various types of IP assets, which we understand. Domain names is one I didn't mention earlier on. This is separate from the trademark. You can own the trademark, you can own the domain name. Never assume that it's automatic, right? They each have to be registered and purchased for domain names purchased. So anyway, you're going to identify and list your IP assets, and you're going to have a list. You'll have the name of the IP assets, the registration details, who owns it, when was it registered, how long do we have left in this registration, or in this exclusivity. In this exclusivity. So you want to make sure that you know all of that. Then you're going to conduct a portfolio analysis. With this, you're going to look at the strength of that particular IP assets, you're going to look at the scope that it has. Trademarks, for example, are territorial. So just because you own a trademark in Nigeria does not mean that you own a trademark actually, it does not mean that you own a trademark in the USA. You have to register it there and in other parts of Africa, even for that matter, for you to have that IP protection. So, anyway, you need to note that. You'll also want to note the relevance of each IP asset within your portfolio and assess factors such as market demand, competitive advantage, and so on. Then you're going to want to evaluate the technology and the innovation. How unique is it, right? If someone comes out today and says, I've invented the internet, I will ask them, what world have they been living in? Because we knew that we've been knowing the internet for a while now, so you want to make sure that you're constantly looking at your portfolio to make sure that, it's still in a position to be relevant and to keep generating, this money or, whatever value it's bringing to the table. Okay. Then you're going to want to look at the cost of cost and investment. You want to know how much it would be if as a corporation, for example, let's take a pharmaceutical company. All right, we find out that there's a lab somewhere in the middle of the Congo that's been doing a lot of work into developing a cure for malaria, or a vaccine for malaria, and we want to purchase it. We'll have to look at what's the cost of acquiring it, how far have they gotten in it? Maybe they're onto something, but it hasn't fully been developed. So how much do they actually need in order to complete this project that they're working on? And then are there other people who might be privy to it? Are there other people who are working on something similar? So what exactly is the value? What are the risks associated with it? You're going to think about all of this when you're thinking about whether to invest in an asset to add to your portfolio. Another thing you might think about is brand value and reputation. It's not every when it comes to acquiring new assets, you want to look into that because that will go into how much you're willing to spend on it. But even on your own, like when you're looking at your own IP portfolio, you are going to when you're doing your evaluation, you'll see, how big is this brand now? Have we been doing enough to maintain the brand value or increase it? Have there been any knocks to the reputation? Maybe someone had a bad experience with it and it went, viral on social media, all of those things will go back towards your intellectual property. And so reputation, brand, image, all of that is incredibly important at all times. You want to have continuous risk assessments, as part of your evaluation process. You want to look at potential infringement risks, litigation risk, competition, and market volatility. What does this mean? You essentially want to make sure that whatever it is your brand is doing, if it's a drug, if it's a phone, that we're managing anything. We're managing everything properly. Any complaints are being addressed as quickly as possible. Is anyone doing anything similar? Are they creeping up on our market, on our market share? Let's make sure that we stay in a position where we can readily defend and protect this intellectual property asset that we have. And so you go through all of that to determine your overall IP portfolio value, and keep on looking at this to make sure that it's performing, that your portfolio is performing as you intend it to perform. How am I doing for time?
Miss, you're almost a bit far spent on time, right? We still want to take the introductions of our other mentors. Thank you, Ma.
All right, thank you so much. So I'll just round up then by just saying that, it's something that we should always think about. And I will hand it over to the other mentors. Thank you again for having me.
Thank you so much, Ms. Zerona, for that wonderful introduction. I'm sure our mentees were able to pick a thing or two on on your introduction, and they were able to gain valuable knowledge. Okay, we'll be going over to also get the introduction of our other mentors. Ms. Amosa Shukurat, please, we would like to have you also give us a brief introduction into today's topic, IP for creatives and innovators. You're welcome, Ma. Ms. Shukurat, can you hear us? Okay. It seems Ms. Shukurat is not yet ready, so we'll be going over to our other mentors. I think Miss Regina is with us. Miss Regina, you're welcome, Ma. Thank you for. Okay.
I think
Okay.
I
Okay.
lost you for
Oh,
some
okay.
minutes.
Okay. Okay. You're welcome, Ma. Please, we would like to hear from you. Thank you for staying tuned. We would like to hear
Okay.
from you also your introduction on today's topic. You're welcome, Ma.
Hello, everyone. Can you hear me?
We can hear you, Ma.
Okay. I would like to say a good kudos to Zerona. I think she has finished the job already. So she made the work more easier for us. So let's just look at intellectual property for inventors, basically. As an inventor, what kind of intellectual property measures or strategy should you put in place? I know we are all familiar with the one for brand name and the one for literary works. So just as brand names and literary works are protected under the umbrella of trademark and copyright, also so as these new ideas that are applied in useful ways can be considered invention and protected as patents. So when we talk about IP for creatives, you talk majorly on the copyright aspect and the trademark aspect, then a little bit of trade secret, because copyright is that actual booming kind of IP basically for creatives. But we'll look at we'll look away from that side and come to the inventor aspect now. So I'll talk more of the IP for inventors than for creatives. So intellectual property, like Zerona has said, is the creation of human mind that is protected from exploitation by third party. So by doing so, it also extends to compensating creatives, inventors for their time, money, and creative process put into creative activities. So just like Zerona said, when you have an intellectual property, what do you do? Or if you have an idea in your head, and this idea is actually original to you, what do you do to even kind of get a way to protect this particular idea? The first thing you have to do is you have to create. Because once you don't create, there's no way you can protect what you have not created. This is to say that the idea in your head cannot be protected without actually expressing it out in a way or the other. Now, by expression, it could be by writing a novel or coming up with an invention or something like that. So the first thing you have to do is you have to create it. When you create it, what do? You protect. So you don't just create and protect, because this is where most of us are stuck at. Yes, because we don't want somebody else to use our intellectual property without our permission. We go ahead to protect it, and we just stop there. So protecting your IP or managing your IP basically shouldn't stop at protection. Once you create it and you protect it, the next thing you have to do is you have to police it, because no one is coming to police your IP for you. You are the owner of your IP, so you are your own first police. If you are not able to police your IP, then how do you know who is using your IP without your permission? And this is where policing comes in. You have to police your IP. And the moment you are able to police your IP, then you know who is using your IP without your permission, and you are also able to liaise or bargain into maybe the person wants to license it and pay for it and so on and so forth. And if not, if the person is not going to stop using your IP without your permission, and they also don't want to pay, what do you have to do? You have to enforce your right. But when you don't police, you won't be able to see if somebody is actually infringing on your IP or not to talk of you enforcing. So when you police and you're able to find out that, oh, someone is using your IP without your permission, then you are able to enforce. And by enforcement, it's probably you sending a cease and desist letter, telling the person to back off your IP. If they are willing enough, you can negotiate, you do a license, how much do you want to collect, how should they use it, in what jurisdiction, and you put the IP contract. And once you are able to enforce, or probably you can do ADR, you go for an alternative resolution process, or you eventually go to court. So that's under enforcement. So along the line, while enforcing, you are able to monetize, because if the person has actually used your IP and probably cost you some damages, then you get monetization, damages monetization from that IP. Or maybe if eventually you are able to settle out of court and the person is ready to actually get a license from your IP, then the person also pay you to use that IP. And by doing so, you are actually commercializing and monetizing your IP one way or the other. So this is just like an example. So the first thing you have here is the idea that I said you have in your head. And on the second image, you have probably you trying to express your idea in paper. Apparently, you have someone that is just trying to, steal your idea. And there's always that person out there that is trying as much as possible to steal your idea if you are not careful, right? And the third image, you can see the person was successful to actually take the idea, but you were able to, catch the person in time, and you're kind of dragging the IP. Okay, this is mine, this is not mine, this is mine, this is not yours. Then on the fourth image, you successfully collected that IP and you are able to protect it. Now, in this instance, if you are looking from the third image and you are not able to put in place IP measures to protect your IP, the person might actually find a way to run with your IP in this aspect. But when you are able to protect and it's protected, it means nobody can use it without your permission, and you are able to monetize it, and you are able to exchange your idea for money at the end of the day. It could be something else other than money. It could be a cross license, it could be co-branding, it could be collaboration, and so on and so forth. So we have types of IP, like Zerona has mentioned. We have copyright, we have patents, we have in trademark, we have industrial design, and we have trade secrets. So I think last week when we were doing the IP for business, we spoke about the categories of IP being broadly divided into two categories, which is the industrial property and the copyright. So under industrial property, you shall find patent, trademark, industrial design, trade secrets, GI, TK, and so on and so forth. So under copyright, you have your copyright and related rights, which is which broadly governs the creative industry, because copyright is like the Cinderella. Yeah, they call it copyright is like Cinderella of the creative industry, because there's nothing you can do in the creative industry without coming along or coming across copyright. So what we have here now, we have images depicting what is protected. You can see a book with chain. So the chain is just like the copyright protecting the book. Then you can see a particular design, C&C channel, that has a logo. Then you can see a kind of know-how, like a gear that's patent. And you can see this very beautiful chair, a sticky chair, that's industrial design. And the last one is just telling you to keep quiet. Just like Zerona said, you have to keep your secrets secrets if you don't have any means to protect it. So we'll look at patents, or let's just see patent basically. So when we talk about intellectual property for inventors, what we'll look at today, we'll look at patents, we'll look at plant variety, and we'll look at industrial design. Now, if you look at these three things, one major criteria is novelty. Novelty. Before you can get a patent for something, that thing you want to get a patent for has to be novel. Same with plant variety, it has to be new. They have other criteria as well, but one major thing you see across these three is that novelty aspect of it. So let's go into patent to look at the definition, criteria, and so on. So what is a patent? Patent is an exclusive right granted for an invention which could be a product, a process, or an equipment that provides a new way of doing something. And a very good example I like to give is the ballpoint pen. So I used to say that back in the days, you know, when our parents want to write love letters to each other, or probably they want to communicate to each other, what they do is they take feather and they put it inside ink and they try to use that to write. But there's always one problem. And the problem is that it smears. Once they close the paper together, everything rubs off and you are not even able to read what is exactly you've written. So that actually is a problem. And somebody was like, okay, fine. So how can we solve this problem? So patent is more about solving a problem in a new, inventive, and industrially applicable way. So you have to look out for newness, inventiveness, and industrial applicability. So we have two brothers, Bic and Biro. They came up with a ballpoint pen, trademarked Bic Biro. And what they tried to do is they tried to solve the problem of ink and feather, carrying ink and feather. You can't travel with it safely. It can pour away, stain the floor, stain your clothes, and so on and so forth. So they were like, okay, fine. How can we solve this problem with a simple material, a simple writing material that you can carry about and nothing's going to happen? So they found a way to put ink in probably a vessel and put it in a case and put the tip where you can use to write, then there's a cover. Now, right from that time till now, you will see that the invention around ballpoint pen has evolved. I know there was a time someone came up with, I don't know if it was patented, but you will see that the ballpoint pen usually have light on it. Even at that time, we're like, oh, I want the one that has light. So whenever you start writing, the light starts blinking. You see the light comes on. Then when you stop writing, the light goes off. And even these big brothers, they also have a patent on, there's a particular ballpoint pen whereby it has different colors. You press it down, you change to blue, you change to green, you change to yellow, you change to black. What problem is that solving? It's actually economical. Instead of you buying a blue biro, a green biro, a red biro, a yellow biro, you can have all of those ink in just one writing material. So that's what patent is about. You have to like come up with something new. Now, it may not be entirely new like that. It could be an improvement of what has been on ground before, but at least you are actually solving a problem in an inventive way. Now, inventive is very important because if what you have done is put 1 + 1 together and you arrive at 2, tell me, why should the government give you a 20 years protection period for something as simple as 1 + 1 = 2, when somebody behind you can still do the same thing? So your invention should not be obvious in the eyes of somebody in that particular field. So that's what patent is saying. So it's like a trade by barter between the government and the inventor, granting the inventor an exclusive period of 20 years. And in return, the inventor discloses his or her invention in detail such that the invention can be recreated by anyone when the patent enters the public domain. So what we are saying here basically is that once you've now filed a patent application and the application has been granted, what do? The government gives you 20 years protection period right from your filing date. Your 20 years start counting from the day you filed that patent. And in return, what do? You have to disclose everything about this invention. Because what we say is like, IP is a private and a public right. In as much as IP is trying to protect the owners or the proprietors of these rights, it's also trying to help the economy as well. So when you have this kind of invention, when it has expired and goes to public domain, the information is out there. So anybody can pick up this invention and still come up with something and still recreate that invention. But the only thing is that you won't get a patent on that same invention, except you've tried to work on that invention, probably upgrade on what the person has done before and have your inventive step and all. But at that moment, you are able to, look at that invention. For example, if probably there's an invention on COVID-19, probably in the US, if that patent should expire, it's something we can pick up in Nigeria and look at it and see, come up with that same invention. It's just I won't be able to patent it, but at least it's going to solve most or some of our problem. Then we can now find a way to upgrade that invention, put in something inventive, and file a new patent application to protect our own inventiveness or our own work on what we have done on the upgraded work. So what are the criteria for patentability? You don't just wake up one day and say, I want to get a patent. You have to put in place, or you have to look at some criteria. And like I said, we have novelty, we have inventiveness, and we have industrial applicability. Now, what can you patent? We understand the definition of patent and we understand the criteria of patent. Now, let's look at what you can patent. Can I just wake up one day and pick my phone and say I want to patent it? You can patent products, processes, and equipment. So by product, it could be your phone. Our phones, we have more than thousands of patents on phones. We have a different patent for the speaker, a different patent for Wi-Fi, different patents for the touch screen, and so on and so forth. So you can patent your product, you can patent a process, probably a process of doing something. You can patent a process, and you can patent equipment as well. Why we have things that you can patent, we also have things that you cannot patent, such as naturally occurring materials or naturally occurring things that occur in nature. You can protect ideas, you can protect mathematical concepts, abstract ideas, the method of, some people don't patent, in some countries, in Nigeria, basically, we don't patent method of treatment, but some other countries patent method of treatment. So one good thing you have to put at the back of your mind is that intellectual property in general is territorial. So wherever or whichever country you are trying to get an IP protection, you need to look at the laws of those jurisdictions and see what's their criteria or what can you actually do in this jurisdiction. I'll give you an example. In some countries, if you want to file like a trademark, they do, in Nigeria, we do a system of first to file. In some other countries, they have a system of first to use. So if you are in Nigeria, you hardly win a case of first to use that you've been using since 10 years and you didn't protect it. But someone that has just been using for probably 2 years has gone to protect your trademark. That person that has protected it and has certificates has a bit upper hand against you or above you, except you have your evidence and you can prove that it was registration in bad faith or the person was passing off your mark, but it's stressful, right? So what we advise is look at the law of the jurisdiction. What exactly can you patent? What can you not patent? What are the criteria for trademark, and so on and so forth. So when you are able to understand the definition of patent, you understand the criteria of patentability, you understand what you can patent. So now you can now look and say, okay, fine, I have a patentable subject matter. This patent application I'm trying to write, the title is patentable and is new. My invention is new, is inventive, and is industrially applicable. So now I want to file for a patent application. What do I look out for? So I have a checklist for patent application here. You have to have a title of the invention. And like I said, the title has to be something that is patentable, a patentable subject matter. Your title should not be, let's say, a method of trapping oxygen in the air. Imagine if governments give you a 20 years protection period for a method of trapping oxygen in the air, and you decide to commercialize that kind of invention. Don't you think people are going to die because there's no enough oxygen, because somebody has already captured the oxygen in the air? Do you understand? So those kind of invention might not be patentable in some jurisdiction. And in some jurisdiction, they are patentable, but you might not be able to commercialize it. So having a granted patent doesn't equate commercialization, because the fact that you have a patent for an invention, it doesn't mean that it will be successful. Because if you are not able to commercialize it, it's just like having to put something in your cupboard and it's not bringing in money for you. So you have to look at the title of the invention. You have to look at the field of the invention. So if you've done something in the engineering field, your field of invention will read maybe a method of producing blah 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 in the field of engineering, and so forth, and so on and so forth. Then you have to look at your background of invention. Now, when you talk about background of invention, you want to give a brief description of what you have done. You want to talk about the technical gap. What has been on ground before? What is the problem you are trying to solve? How are you trying to solve it? All of this will be under your background of invention. You talk about summary of invention. You give an abstract. If you have drawing, you attach your description, you give a detailed description of the drawing. So if you have labeled your drawing, probably how does 1 connect to 2, how does 2 connect to 3, how does 3 connect to 4, you itemize and describe everything under where you have detailed description of drawing. Then you had your drawing in different views, your front view, your side view, perspective view, and so on and so forth. So you're able to, the examiner is able to holistically see whatever it is you have done. And last but not the least, your claim. You have to draft your claim in such a way that it speaks to your description. Because if whatever you have in your claim, if it is not in the background of the invention, or if it is not in the description itself, then you cannot get a patent application for that. So your claim has to speak to your invention, and it has to be in a way that everything goes in and out. And you should try as much as possible not to have a very broad claim. So I have types of patents here actually, but I really don't like to call it types of patents, because in Nigeria, our Patents Act, our Patent and Design Act says that we can't protect plants and animals, right? However, in some other jurisdiction, they can protect plants and animals. And if you go and browse, what you see is types of patents. So you will see patent, plant patent, design patent, and utility patent. But in Nigeria, like I said, under our patentable subject matter, plant and animal are not patentable. So because of plant and animal are not patentable, we really cannot call plants a type of patent. Yes, plants has some criteria that patent also has, but you just like to differentiate it from patent. You can say design patent and design patent, that's industrial design. We call it industrial design here. But if you are browsing, you might see more of design patent and utility patent. But you might also get confused because we have, aside the normal patent, we also have utility patents in Nigeria. Some jurisdictions don't have utility patents. So that you just don't get confused, patent is the general patent. Industrial design is what they call design patent in some other jurisdiction. However, we have utility patent. Utility patent is like a smaller patent because it doesn't require the level of inventiveness required in patent. Then we have plant varieties. They call it plant patent in some other jurisdiction, but we call it plant varieties or plant breeders' rights that protect the rights of plant breeders. So just for you to understand that aspect. Then we move on to industrial design. Industrial design is the ornamental or aesthetic aspect of an object protected from unauthorized use. So look at this pencil I have here. Should I say pencil or crayon with a kind of bulb around it? If you have this kind of, if you are giving this kind of pencil and I give you just the random pencil that we use, which one are you going to pick? For me, I'm going to pick this one that has bulb because, I mean, it's more beautiful. It's aesthetic, right? So that's what industrial design is all about. It's not about the functionality or its technicality. It's just about how beautiful it is, aesthetic, basically. So if we have two sellers or two manufacturers producing this kind of pencil and the normal pencil, I tell you, this one is going to sell more because of the design, the appeal it has to people. So industrial, these are example of design. So if you have these are example of bulbs and they have different designs. So which of these designs are you going to pick? So that's industrial design basically. Oh, I omitted this criteria for industrial design. It has to be new and it should not violate public morality. Like I said, every jurisdiction have their own law. In some other jurisdiction, you will see novelty and what's that word? They don't use violate public morality. They use a particular word. I'm trying to remember now. When I remember, I'll tell you. So let's look at plant variety. So oh, okay. It's incomplete actually. So plant variety protects plant breeders. So let's assume I have a particular seed I want to plant. And when I planted that seed, I noticed that the seed is a seed that I can actually protect and make money from. But you have to meet up with the criteria for plant variety as well. It has to be stable. It has to be uniform so that once you plant, you make sure that whatever outcome you are going to get, it has to be uniform. It's not as if you get outcome A today and tomorrow you get outcome B. No, that outcome has to be uniform, because if I give you protection on something that is not uniform, it means even we probably do not know what we are doing. So plant variety also adds its own criteria. Then we look at trademark. So now I said for inventors, basically we look at plants, patents, industrial design, and plants variety. So let's now assume you've probably come up with an invention, and now you want to sell that invention. You have to give it a name, right? This is where trademark comes in. So when the big brothers came up with the ballpoint pen, like it's called ballpoint pen, that's generic name. So they needed to give it a name to sell in the market. So they named it Big Biro, because we have two brothers, Big and Biro. So they joined their name together and named it Big Biro. So Big Biro is the trademark that is used to sell that particular material. So what is trademark? Trademark is any sign capable of distinguishing the product and services of one enterprise from that of another enterprise. So these icons you have here, when you look at this, you know this is Meta and this is iPhone, Apple products rather. So what are the criteria for trademarkability? Do you just wake up one day and say, oh, I want to trademark my logo, or I want to trademark my name, I want to trademark my slogan? You have to look at the criteria as well, because if you don't meet up with this criteria, you can't file a trademark. And even if you are able to file, you might not get a certificate, because during the opposition period, someone can come along and say, oh, this mark is descriptive, is not distinctive, or is violating public morality, or is generic, and as such, you get your trademark taken off the trademark registry, or opposed or revoked. So it has to be distinctive, it should not be descriptive, it should not be deceptive, it should not violate public morality, and it should not be generic. So what can you trademark? Shape, your names, your symbol, your slogan, your color, logo type, as long as it can identify and distinguish your brand in the marketplace, it can pass for trademark registration. We also have sound mark, smell mark, and so on and so forth. But in Nigeria right now, we do not protect non-traditional marks such as sound mark, smell mark, but there are in some other countries, they protect sound mark and smell mark. And an example is the Nokia ringtone. We also have Play-Doh. Play-Doh has a particular distinctive smell. That smell is trademarked as well. So what's the benefits for registering a trademark? It gives you exclusivity. In fact, all IP gives you exclusivity, gives you ownership, gives you monopoly. You have competitive edge in marketplace. You are able to your customer is able to differentiate your product, just like the owner said. Your trademark basically is, it gives your consumers that trust in you, that okay, I'm buying the perfect brand I want, I understand their quality, and I align with their brand goals, and so on and so forth. So as a business owner, you need to understand this as well. And one last thing I would like to say is, most of the time, intellectual property kind of overlap each other. So you have to know which IP is actually right for my business. So in an instance whereby you are running a restaurant and you have trade secrets that you use in probably mixing your recipe and so on and so forth, and you are wondering, should I actually keep these secrets, or should I file a patent application so at least I can get a 20 years protection period? You need to ask yourself, which one is best for me? What's the best route? Should I do a trade secret by keeping quiet, or probably when I want to expand, I put in a confidentiality clause or a non-compete clause and so on and so forth? Or should I actually disclose these my trade secrets and file a patent application? You have to look at it like, which one is better for my business? By doing this, you have to look at your business strategy and now find a way to put in your IP strategy and see, okay, this is the best for me. An example like Zeriona mentioned is Coca-Cola. Coca-Cola does not have a patent. What they have is a trade secret. Now, imagine if Coca-Cola had decided to go through the route of patents and get a 20 years protection period. By now, their The patent application will be everywhere in the public domain, and everybody will be able to use their patents by now, their patents in the public domain by now. But because they actually opted for trade secrets, they have put in measures to make sure that that trade secret is kept secret and nobody is able to divulge the information. So you have to look at that. Okay, so I'll be rounding up now. So as an IP enthusiast, you have to be able to advise your clients by looking at their business strategy and also looking at their IP strategy and look for a balance. You have to look for a balance. If your client should say, oh, I want trademark, you need to look at which one is better for you. Should they use trademark? Let's say you have a particular shape. Should you do trademark or should you do industrial design? Because these two also overlap. So you need to be able to give very good advice. And you also have to look at the IP management, monetization, and commercialization. Like I said, it shouldn't end at protection. You need to look at policing your IP, enforcing your IP, and monetizing your IP. So I'm going to end my presentation there. I think, so this is just the guesswork. Then protection period. Our trademark lasts in Nigeria, trademark lasts for 7 years initially and 14 years consecutively. If you keep on using your trademark and you maintain it by paying your maintenance fee, it can last indefinitely. Copyright will last throughout the lifetime of the author, and 70 years after the death. Patent will last for 20 years. Industrial design will last for the first 5 years and 5 years consecutively. So altogether, you have 15 years in total. So what's the difference between design, patent, plant variety, and trademark? We already discussed that. So this is just like a brain work. And I'm going to end my presentation there. Thank you for listening.
Thank you so much, Ms. Amosa, for giving us that thorough rundown through today's topic. Thank you so much for doing justice to today's topic. We also still want to hear from our other mentors. Can everyone hear me? Please, can you all confirm that you can hear me?
Yes, we can hear you.
Please, we'll still want to hear from our other mentors. I think Miss Regina is with us. Please, Miss Regina, please, we'd like to also hear from you. Thank you so much for joining us, ma. Miss Regina?
Yeah, hi, Dennis. Can you hear me?
Yes, we can hear you, ma.
So at this point, I think that Zarona and Shukurat have done justice to this topic. But if you have a little time, I can just say one or two things from my notes.
Yes, ma, please, you can go ahead, ma.
Yeah. Thank you, everyone, for having me. And very briefly, let me just run through my notes. They've said basically everything you need to know on this topic. I have here who is an inventor. I guess you all know who an inventor is at this rate. Just a minute. So I guess you all know who an inventor is at this rate. An inventor is an individual who invented the subject matter of an invention. I hope I'm audible. So if you lose me anytime, just let me know. In Nigeria, inventions are protected as copyrights under the Patent and Designs Act. An invention may apply for a grant of patent by the relevant government in Nigeria, the Patent and Designs Registry, which is a department under the Ministry of Trade and Investment. So after an examination in Nigeria, we know that patent is examined as to form. So after the examination, the patent is likely going to be granted or refused. So recently, the Patent and Designs Registry have been sort of refusing or clearing some applications for certain reasons. So if invention is granted, the inventor or patentee is granted the exclusive right to exclude third parties from exploiting the invention without their prior authorization. So to kind of divert a little bit, I'm going to be speaking briefly on the concept of AI in patenting. I'm sure we know what AI is, artificial intelligence, and it's simply the intelligence of machine as opposed to human beings. And we know that there have been major controversies as to whether AI can or should be legally recognized as an inventor. Of course, in Nigeria, based on our instant laws, it's most likely not going to be recognized as an inventor. Looking at the provisions of the Act, looking at section 2, 1, and 5, it is explicit that an inventor should be a person, should be a human being. Moving very quickly, there are three school of thought on this argument, one of which says that so one of the school of thought recognize an inventor as a patentee capable of being granted a patent rights. For instance, some jurisdictions like South Africa and Australia, we understand that the decision in Australia was later overturned, and some other jurisdictions hold that AI cannot and should not be allowed to hold a valid patent, such as US, New Zealand, Japan, and the like. In US in 2020, we understand that the USPTO refused to grant patents to an AI, and it stated that only natural persons can be inventors. And some other jurisdictions actually hold that a patent application with an inventor must identify at least one human inventor, and such jurisdiction is the AUP, that's the EPO, European Patent Office, and the UK, and some other jurisdictions. And moving quickly to creatives, where I believe we understand who a creative is, as a person whose job is to create. And this could be likened to the content creators that we have all over Facebook, TikTok, the internet. And we understand that this is now a major source of income to most individuals. So the Copyright Act, as we know, is the primary legislation that protects works of creatives in Nigeria. And trademark may come in also at some point, protecting trade names and brand names. We are aware of popular names such as Oga Sabino's, Kiki, Mr. Macaroni, and the others. Most of these trademarks have been duly trademarked in Nigeria. And also to mention before I round up, I'm rounding up already, copyright law is the most progressive IP law in Nigeria at the moment. And under the Act, there are works which are eligible for protection, and that simply means that there are also works which are not eligible for protection. And that is, I believe, is basic. It's basic. Most of the laws, most of the works which are not eligible for protection as provided in the Act, ideas, Shukurat had mentioned that where she was describing works which are not, inventions which are not eligible for patenting, ideas, format, concept discoveries. If you have a mere idea, a mere data without any additional input, these and many others, official state symbols, such as the Nigerian flag, the coat of arms, the national anthems, they are not, the banknotes, the naira, they are not eligible for copyright protection. And the works which are eligible for copyright protection, the literary work, the musical work, artistic works, broadcasts, audiovisual works, and sound recordings. So IP for creative and inventors is a very interesting topic. Due to time, I would hand over to the moderator. Thank you very much. I hope I was audible. I am done. Thank you. Thank you for the time.
Hi, is Dennis still on the call? I think.
I think he dropped off. I had requested to be the last mentor to speak. So I'm not sure who is pending and then me, so we can continue so that we just save time. Perhaps he has an internet issue.
Marx, can you hop on? Mr. Ikongbe. Okay, Dennis is back now. Great. Hi, Dennis. Regina finished her presentation, so I think you got pulled off for a moment, but if you could introduce the next host, please.
Okay, thank you, Ms. Zerona. Thank you for helping me out. Sorry, my network has been really crazy today. But thank you, Ms. Regina, for helping us also give perspective to today's topic. We'd like to have our next mentor, Mr. Max Kombe. Please, you're welcome, sir. We'd also like to hear from you and to draw insights from your own perspective on today's topic. Thank you, sir. Mr. Max, are you still with us? Okay. It seems Mr. Max is not currently available. Okay, we'd like to hear from Miss Liz. Please, Ma, we would like to also hear from you. Just maybe briefly, your own perspective and your own thoughts about today's topic, Ma. We would also like to hear, especially considering that you have a more non-Nigerian perspective in that sense. Ma, we also want to hear from you from a broader or wider horizon concerning IP for creatives and innovators. Welcome, Ma.
All right, thank you so much. I believe this is the same group from last week, yeah?
Yes, Ma.
Okay. So I think a lot has been said by the previous mentors. So I'll talk a bit about contracts, because I think when inventors and the creatives are starting out, it's the one thing they never think about. And sometimes people are so held up in the idea of registering and they forget about the ecosystem around them, which is the people they are working with, the people they are brainstorming with. So I think, if you're an inventor, you want to figure out who are you working with, who are you collaborating with, and how. I'll give an example of like the software industries in Kenya. You'll find that the collaborations tend to be between someone who has money, a financier, and a software developer. So the financier has zero knowledge around software technologies, and they just have this idea they want executed, right? And they're like, I'll pay you X amount of money. But you find that the software developer most of the time may either be naive, or they just want the next paycheck. So they don't sit down to interrogate, what is my role here? So I'm creating, but who's exercising the creative control and things like that, so that they're able to negotiate a better deal for themselves. And even if it's a work for hire agreement or arrangement, what else can you get out of it? Because again, also, it's always important to understand that even as an inventor or as a creative, there are different type of models. There are business models where you are work for hire. You're hired to develop stuff for other people. You get paid and you move on. And it's also a lucrative area, or aspect in the IP business. So if you are more the work for hire, or you embrace work for hire, then you want to negotiate good contracts for yourself. It means if it's maybe a good payday in the contract, and then maybe get a service level agreement, like a software developer would want also to negotiate to be the maintenance personnel for that app they create for the next X amount of years, make it a more lucrative deal. So that was one example. Another example is, you are outsourcing some materials to either construct something. What kind of contracts do you get into with the people who are manufacturing some of these elements? So you find, again, it always depends with the nature of labor also you engage. Like in Kenya, we have who we call like the Jua Kali sector. These are the guys who are, the manufacturing is done by hand. So they don't have a lot of sophisticated machines, but they still get an equally good job done. But you find that for them, mostly their level of education is not so much. So how do you engage such people? They are vital in your business ecosystem. Or even a tailor, for example, if you're in fashion, what kind of contracts do you have? I've interacted with business people or inventors and creatives who are like, what does this guy know? He didn't go to school, so does he even need a contract? And then a few months later, they are crying because of the losses that they're experiencing. I'll give an example. There's a Kenyan business that started a very unique way of, they had a very beautiful design of safari tents that were being used in the Masai Mara and some of these, luxury tented camps for glamping and whatever. So this guy, he never used to think about IP, and he used to say, "Oh, my driver, what does my driver know?" So while he's in the car, he's talking about his designs, his he's very elaborate with his business deals on a phone call in the car, right? He'd even talk about his suppliers, like all that stuff. Again, as an innovator, you have to realize that there are so many elements that are protectable, including your database of suppliers and clients and whatnot. So he would be there, he's talking about everything. So you can imagine the driver, just from driving and chauffeuring him around, he literally took notes mentally around where was he outsourcing his metal, where was he outsourcing his canvas, all those things. And then eventually he poached a couple of his workers, and he started duplicating those designs of the tents. And he now started cutting him off the supply chain. So he started getting more of the deals. And this guy quit being his driver. And the next thing, he's being told, "Oh, I've seen you did another camp in the Mara." It's like, "Oh, I've not done that camp." And I'm like, "No, but they're your designs, they're your tents." And he's like, "No, that's not me." So eventually he learns that it was his former driver. So you can imagine how it was an egg in face type of moment. And, he even needs to talk to about him in a very derogatory manner. And, he's just like, this guy is a nobody. So again, you have to be attentive about the people you are working with. It's a receptionist, you know, you have a fashion design house. Again, I had a similar situation where a receptionist stole designs from her employer and started competing with her and opened an online shop and literally duplicated the designs. She just went for cheaper fabric, but she had seen how the patterns were being cut. Like she was privy to everything that was happening in that fashion brand. Again, and there was no contract. In this instance, it was the designer had hired a cousin from the rural area. You know, she got a call and she said, oh, so-and-so's daughter is looking for a job. Please give her a job. You know, same, you know, African stories, right? So again, in this instance, she was like, what does she know? She's from the village. Shock on her. So like I said, contracts become really important. What are those? And again, at the same time with the contracts, they have to be well drafted. So it's always important that, you know, the lawyer is very intuitive in the drafting of the contract. You have to walk like 10 steps ahead, 10 steps behind, and still see, you know, what lies in the future, or you can at least anticipate. So you can imagine what kind of contracts those look like. When you're dealing, in my perspective, when you're dealing with those who have not gone to school or lower level type of labor, you know, you want your client to understand that they have to explain the legal process, explain why it's important, so that then the legal aspect is embraced from the beginning. It's really hard to get an employee to sign a contract 1 year down the line or a few months in, you know. So you find that in such instances, those who introduce contracts halfway into an employment engagement, most of these guys run away because, again, when they hear the law, they're like, are you going to take me to jail or whatever? Because they've not been explained to. So it's always important that you have those conversations. And then on the other hand, if you are, you know, collaborating with now the more sophisticated, well-educated type of partners, again, you have to be very keen, right? If you are the inventor or the creative who's bringing this particular asset to another person to collaborate and work together with, you should be the one bringing the contract, not the other way around. And unfortunately, what normally happens is that if the other guy is bringing in the money into your business, you find that they always be the one to bring the contract, and they'll bulldoze the situation, and then it stops being a negotiation and it's almost a hostage takeover. They're like, you know, this inventor or creative is desperate, take it or leave it. And you find most people will just, you know, end up taking a bad deal because they're like, okay, this guy waved some good money or some money that I needed. I'm like, what is the harm? Where is the harm? But unfortunately, there's always a big risk. Creatives are always losing something somewhere when they don't negotiate a deal. Inventors are always losing something when they don't negotiate a deal. I'll give another example. Here in Kenya, we have university students, maybe now it's like 25 years ago or so, because I think they're around my peers right now. They invented a parking system. It was their thesis in their university research. And then I think it was their lecturer or something thought it was really amazing. So he presented it to a friend of his who is a serial entrepreneur. And then he told him about his students. And then somehow, somewhat, because these kids did not understand about IP, and I think they just sort of they were happily swimming in the sea of ignorance. They get employed, get these amazing employment agreements. They're getting paid good money, but now they're being paid to now fine-tune their innovation. So by the time they realize that, you know, oh my gosh, this is actually our stuff we are working on and we could have done better, it was too late. This guy's already registered the innovations and whatnot. So their ship sailed like that. So now they're just known as the CAPS guys. The system is called CAPS. Again, contracts are a really big thing. If you're going to work with, you know, some cross-border interactions or arrangements or transactions, you know, be it, let's say in the creative sector, two artists are writing a song together, I'm manufacturing my stuff in China. Again, those contracts are really important. And one of the things we always forget to think about is the dispute resolution clause and the what we call the conflict of laws clause. Which law are you going to you know, pursue in the event of either a disagreement or an infringement or, you know, a breach of contract? So again, that issue of the jurisdiction, which courts would have jurisdiction, is always important to pay attention to. And then the issue of also, you've had appeals territorial, right? So again, when you're collaborating with international partners, then your IP strategy will have a more multilateral approach, such that you ensure you protect yourself in the country of the person you are collaborating with, in the country of manufacturing, and as well as in the countries that you anticipate your product to sell more, or the markets that you have targeted. So you have to protect yourself at least from the beginning, so that you don't find yourself on the losing end of the stick. Again, you've heard from the previous mentors, understanding then the laws of this particular countries that you hope to transact in as a creative, and you're advising as a lawyer. Then know also the lay of the land at the time at which you the inventor, or you the creative, or your client the inventor or creative is creating something. Again, if you can see a trademark and you've had at least some conversations around what do they want to do with it, especially like products, then you also want to ensure that you do a simple search or research, just to know, like for the sake, like in the case of trademarks, does this word, it might be in a Nigerian language, what does this word mean in Kenya? Because in Kenya it might mean a derogatory thing. So that means then you might have to figure out how you will rebrand in Kenya, for example. So then does that change your brand name, your branding strategy and things like that, so that you don't find yourself in a situation where you have this particular asset, and then in Kenya it's known as one thing, in South Africa it's known as another thing, in Nigeria it's known as another thing. So then you look like a very haphazard inventor or creative, right? So I think, again, in that instance, whenever an inventor or a creative is working on something, those are some of those pertinent things that they really need to look at. And they start working from a vision. I think it's always important. So, but I think I reiterate that contracts, really important. Again, the whole issue of gentleman's agreement is really killing the inventor space, the creative space. People don't have contracts. So the minute you don't have a contract, then you lose on a lucrative deal, because if someone wants to interact with your intellectual property, they want to license it. If it's in music, they want to license it for a film, or for example, a documentary. No split sheets. There's no way they're going to touch your music, right? If someone, how do you assert you have some rights, either in a patent or a design that's going to be used in a certain in a different production or something, right? How will you license it without some sense of protection, some registration as well? You have to make sure that all those things are in place. If you work together in a project, again, the IP clause should be very clear. How are we splitting it? Who is in control? Because again, when two parties are, trying to do the same thing, that ship will sink. You will lose a lot of monetary value because, for example, if Dennis and I do a collaboration, then Dennis puts it on his YouTube, I put it on my YouTube, we're going to split the eyeballs. So if we're going to look at revenue at the end of the day, we won't make much revenue because there will be others on his channel and others on my channel. And yet, if we had one single channel, we'd have more eyeballs, more revenue, which we can split fairly and as agreed. So again, in a contract, who has the right to control? Who has the right to negotiate contracts, or what is the reporting mechanism? Like all those things need to be thought about, because the creative industry, the IP industry, the innovator space is very collaborative. So the minute the partnerships and collaboration contracts are not well done from the beginning, you find that most of our startups, they hardly ever thrive. Like they get to a space or a stage, and then they just die. They just die, and it's not a natural death. It's just an ugly death because people are fighting over money. People are fighting over opportunities they had never agreed from the beginning. So I think for me, that is one thing that I really thought that I would shed more light on, and always persuade that we always have to remember the contracts, well-drafted contracts. Confer and consult on some of these contracts. Don't assume you know everything. Again, and please stay away from this Google lawyering. Yes, you will find an amazing template online, but it's something that you want to make sure that you read. If you have clients who decide to go on Google to download templates, please, they're disrespecting your law degree. So put them in check, because I've been in a situation where a client thought they had signed an amazing contract, only for it to come to me and it said it was, they had submitted to the laws of, I think the state of Atlanta, Georgia, Atlanta or something. And I was like, dude, did you see this clause? He's like, oh, I just downloaded it from the internet. I'm like, okay, unless you're going to Georgia to sue this case, I don't know what we are doing here. So he was shocked and bamboozled and everything. So I think that is my piece in regards to this conversation. And yeah, thank you so much. Back to you, Dennis.
Thank you very much, Ms. Liz, for that wonderful contribution to today's topic. We still have one more mentor, right? Mr. Max, are you still with us? Are you with us, sir?
Yes, Dennis, thank you. Thank you.
Yes,
so
sir.
Can I go now?
Yes, sir, you can go on, sir.
Okay, thanks so much, Dennis. And permit me to first of all thank the program journalism Jiipcc for having me back again for another cohort of this wonderful program. I also want to thank all the other mentors who have gone before me. I saw the powerful slides presentation by my madam, Amusa Shukurat. That was really powerful, well done. And then, of course, to the others, and particularly to Liz, I enjoyed the very practical approach Liz took to introducing you to the topic. Because it's unfortunate that a lot of times as advisors to businesses, particularly startups and creatives who usually are very informal about their approach to business and all, you increasingly have this very heartbreaking scenario where by the time the creative or the inventor comes to you, it's already too late in the day because they've made some fundamental mistakes right from the beginning of their business, and it's really not possible at that point to remedy the situation anymore because the underlying agreements are so badly stacked up against them that you are not likely to get any benefits for them, even if you choose to take the matter up in court. So sometimes you are forced to rather negotiate a deal that is, the second best option. You are left it at that point in time. But what I just want to emphasize from my own perspective today is encouraging everyone here, because you're all training to become advisors, IP advisors, sometimes lawyers, to inventors and to creatives, to always, as much as you have the opportunity, to look sometimes beyond just the specific IP needs of the business, but to take a broader look. Because what I found in my own experience that a lot of times when you take a broader look at sometimes for a creator, the invention or the innovative product that creator has come up with, when you take a deeper look at it, you begin to find that sometimes it's not just the IP doesn't always lie on the surface. And sometimes the IP type you choose may end up even not being the best fit for that business or for that situation at that time. So sometimes learning how to combine the different IP types and come up with a solution that works is better than just going with a one-size-fits-all approach. So I tell people, for an inventor, not everything in invention is about patents. Sometimes what you need is not patent. Sometimes what you need is a trade secret, because the invention you have sometimes is, the fact is that it's already been disclosed to an extent, that getting a patent on it might not be feasible, particularly for jurisdictions like Nigeria, where there's no examination, no substantive examination of patents. The patent you have sometimes is really not what a paper is written on, and you would never tell until there's a litigation. And then, both parties have to call expert opinion, and then you might find that the opposing party calls an expert who gives sufficient evidence to show that as at XYZ date when you took out your patent, that invention was already in the market. So it's risky. But in jurisdictions where substantive examination is done, usually at the point of the grant of the patent, the substantive examination might show if that invention is indeed novel or it's already been put into the market somewhere else in the world. So I don't know about Kenya, and I'm sure Liz would educate us on that. I don't know if Kenya does substantive examination, but in Nigeria we don't, and a couple of countries don't do that substantive examination. Of course, it's not all bad news, because as the advisor, the IP advisor to that inventor, it is part of your duty, even if the trademark, even the patent registry is not requiring to conduct a substantive examination. But as part of the due diligence, when you are briefed, you should also at least do some level of a search to find out if indeed the invention is novel. And like I tell people all the time, even if your search reveals that the invention is not novel, that's not bad news. What you need for to get a patent is either a new or an improvement. So even if your invention is not exactly novel, it's not completely new, but if you can find a distinctive factor that is totally new with respect to your invention, sometimes it's an improvement, sometimes it's simply a customization. There's an invention that works in Europe, but when it comes to Africa, it doesn't work well because of the temperature. So the fact that you're able to find a solution that makes that invention work in the climatic conditions of Africa itself entitles you to get a patent on that improvement. So in advising inventors particularly, that should be some of the advice. Then something that I think is also lacking in Africa is that there are many parts of the world, particularly in China, where some inventors, the only business model they work with is simply this idea of getting improvement on inventions. So what they do is to, monitor very closely, inventions that are falling into the public domain. That means that essentially, I'm sure by now you know that for a patent, it lasts for 20 years. After 20 years, it becomes available for everybody to work that particular patent. So what some businesses do is that they simply watch out for patents that have crossed their 20-year mark and are falling into the market, and they pick those patents and find a way to create an improvement on that patent, sometimes a simple customization of that patent. So at the moment, if you look at the recent statistics for the past, I think, 3 to 5 years coming out of WIPO, the greatest number of patents are currently filed in China. And to a large extent, a lot of those patents are improvement patents. Those are patents that is just an improvement on existing. Some of them are customization patents, a patent from the US, from Europe, and somebody in China customizes that invention to work in a unique way within the climatic conditions of China, and then he gets a patent on that. So I think Africans need to wake up to that reality as well, that there's a lot of innovation out there that we don't need to reinvent the wheel. As an inventor, you don't have to start from scratch. You can just pick up some of those existing inventions. Sometimes you combine two inventions and come up with a third powerful invention. That's also a way to go about it. Sometimes you customize, like I already mentioned, or sometimes you simply improve. These are different ways that inventors can still cut themselves an edge and also get patent protection. Then for creatives, I mean, Lisa has said so much, I don't think there's much more to add. But for creatives particularly, it's really saddening when you see this condition a lot of creatives are in. They're just passionate about their craft. They just want to express themselves and all of that. They are not thinking at all about protecting themselves, about the IP protection and all of that. In Nigeria, they're a little bit fortunate because the Copyright Act 2022 that was effectively passed last year has created some greater level of protection, by, making some default provisions in the law that inure to the benefit of creatives. But beyond that, creatives must continue to educate creatives to really take their time to understand what they are doing when they sign that dotted line, to really understand some of the issues, what they are signing away, and weigh carefully the cost-benefit analysis. Because again, like Lisa had mentioned, a lot of times for them, it's just about getting the next paycheck. They are not really bothered about all the grammar you're telling them about licensing, about retaining some of their rights, about limiting the license they are granting to the record label or to the management company signing them. So it really behoves on us as IP practitioners to really go out there. I mean, somebody like Amosa does a wonderful job on Instagram, putting out information, on IP and all of that. That's sometimes the only way you are going to reach these creatives. You are not going to reach the creatives just by sitting in your offices, because they won't come to you before they sign that deal. So we have to find a platform to reach them with that information on time and warn them of the risk. And I mean, the work happening on social media is going to bear fruit, because many creatives are now becoming more conscious and aware that they need to consult specialist lawyers in IP and entertainment law before they commit themselves to any deal. So that's begin to pay food. So for you, entrance into the field, this is the market that is before you. You need to go out there and make your own market. You need to be actively, engaging and, doing the work of educating. So of course, the education is usually free at that point, but the hope is that as the education goes out over time and this, these creatives become more aware of these things and they come, of course, they have better deals, with time, they are able to really pay for your services. So having said that, I'll just end on the note that IP, you must note, for those of you starting this program, IP is like the cocoa tree. It's not like farming maize. If you farm maize, you get a harvest the next year. But when you plant a cocoa or a palm tree, you might have to wait for 5 years, 7 years before you begin to get any return on your investment. So for myself personally, I got into the IP space. At some point, I got discouraged because it was like, there's just no money in this field. Because it took a long while, to gain knowledge, to keep trying to get visible in the market, really have clients come to consult you. So it will take a while, but it's worth the wait. Because ultimately, IP being an area of law that is itself based on intellectual work can only grow and expand, unlike some other areas of the law that might shrink. IP is only on the upward rise, particularly in Africa. We have not even scratched the surface yet. We are just about scratching the surface. So getting into the IP space now in Africa, you are headed in the right direction. Just ensure that you endure sometimes the long ride it might take to really get to that point where IP begins to pay you big time. So once again, I congratulate all of you for joining this program. Of course, I look forward to other sessions with you. And my hope is that in no distant time, you'll become a major player in the IP space. Thank you. And back to you, Dennis.
Thank you so much, Mr. Marks, for that wonderful introduction. We've spent I think almost the whole time just on introduction. That's how vast the IP space can be. But still, yet, irrespective, we'll still be taking, I'm sure our mentees have learned so much in this hour or two that we've spent. Our mentees just dishing out wisdom back and forth for us to learn from. But we'll still be taking our presentation. So we'll be having our group presenters come make presentation. Since we are fast spent on time, we'll just have the presentations very fast. Group one presenter, if you can, 5 minutes, let's come and have your presentation so that we can continue with the class. Thank you very much. Group one presenter, yes. Thank you, David.
Good day, everyone.
Yes, good day, our
Can
presenter.
you hear me?
Yes, we can hear you.
Okay. I'm in group one. I'll be presenting on intellectual property for creatives. Hope you guys can hear me. I'm having network issue here.
We can hear you. We can hear you loud and clear.
Okay. As we can see that in this world today, creatives are not scared of putting their work out there because there is an intellectual property right that has this covered. And some of these rights could be copyright, trademarks, patent, industrial designs, and so on. Also, the existence of those rights provide creatives with the sense of security and confidence to showcase their work out there. And also, this security enables them to monetize their rights. And also, it brings about a win-win to the audience and also to them. Moving on, we're going to literary works. Under the literary works, Section 9 of the Literary Works Act give the authors or the owner the exclusive right to authorize their work or to give another person the right to make use of their work, to reproduce the work, or to publish the work. Reproduction of this work means they can have the right to produce the work in different copies. Then publishing of the works means they can also have the right to publish their work in public. Publishing of the work can be in form of physical, electronic means. We all know the meaning of physical means and electronic means. Physical means going to the bookshop or stationery to get your book paid. That's the physical means. Electronic means here, the form of going to Amazon or any app to purchase a book also is an electronic means. Now we move on to visual work, sorry.
Or is it me?
What is worth copying can also worth protecting. So it is important for the owner of this visual painting to protect their work, to protect their art from another third parties without their permission. Also, we'll move at dance. If your dance must show that this your dance step or dance move is original. You cannot copy another person's dance step and then you want to protect it. You must show that this dance step is original and also in a material form. What do I mean by a material form? It must be written down, documented or recorded. Any means you feel like doing it, just make sure that it is in material form. We'll be moving on to film making. It is important to know that the foundation of every film production lies under intellectual property rights. Copyright gives creators the exclusive right to use their creative works, such as screenplay, performance, or musical composition, and also stop the another individual from using them. The film industry using intellectual property law to ensure restriction.
Okay, it seems
for the
our
very
group
important. Therefore,
presenter.
so you cannot hear me. Hey, Jesus. Network is very bad.
Okay, we can hear you, but talk is. But you can continue.
Okay, sorry. Okay, as I was saying,
Please continue.
under the filmmaking, don't forget that music is also a very important element in filmmaking. Therefore, for you to use another person's songs in your filmmaking, you must pay royalties to the original composer of those songs to avoid a case of copyright infringement. We'll move to music. Intellectual property rights ensure that designers, artists, and creators are generally recognized and compensated financially for their creations. For every musician, copyright protection is of extreme importance because it protects both the written and the sound aspects. Now you will see that it's not only about the written aspect that intellectual property rights protect, it also protects your sound aspect. So if you feel like you want your sound to be for you alone, for your industry alone, you can also protect the sound aspect. That is to say, you can look for a lawyer to register this your sound for it to be for yourself, for your industry. For another person to use this sound, then they have to seek for your permission or your consent. The musician works cannot be tampered with unless authorization is granted by the recording studio. Now we'll be moving to another one. Is it the fashion? Okay, the fashion designers are protected from being copied through a mix of patents, industrial designs, copyright, or trademarks. Most fashion brands now rely on trademark protection to protect their brand, including the packaging and the product appearance. You can trademark the shape of your clothes, the logo, or the style of your fashion design. Another one is comedy, if I may ask. Sorry, network issue. Another one is comedy. Sorry. The protection of comedians intellectual property. Okay, let me look at broadcast first before comedy. Broadcasting and distribution can only be done for your, you can also protect your recording, your by intellectual property rights. Another one is comedy. The protection of comedian intellectual property proved to be a hard task sometimes. Comedians often neglect the protection of their creative works, which makes joke theft. But where it is protected, other comedians cannot copy their work or job without their permission. Hope you people are hearing me. Sorry. Hello.
Yes, we can hear
Yes,
you.
we can hear you.
Okay,
Yes, we can
sorry.
hear you. Go ahead. But please, we would like for you to start rounding up your presentation.
Okay, let me look at software programs. Protection of software programs in intellectual property rights is done through patent. Once the legal right for the software has been obtained by the creators, no other company can manufacture or market it unless it's licensed to them. The right belongs to the company used by another entity is considered illegal. Let me look at the important because of time. As we all know, a contract is referred to as an agreement between two parties, which is legally binding. It certifies the condition that any certain obligation will be fulfilled by the both parties. Therefore, a contract in the creative industry does not only ascertain security creative works being used wrongly, it equally enables number one, timely payment, 2, easy, 3, procedure for dispute resolution. Thank you.
It seems we've lost our group presenter. Okay, group 2, please, can you come up and quickly make your presentation so that we can continue with class? Group 2, can the group presenter from group 2 come up and make her presentation or make their presentation?
Good evening, everyone. Can you all hear me?
Yes, we can hear you, Mr. Sunday.
Okay, I am the backup presenter for Group 2. The presenter is not available right now because of some reasons, and I will be the one to present. So I will share the slide now.
All right, thank you, Mr. Sunday. Please, we'd like for you to make it hasty. 7 minutes. Thank you. Okay, Mr. Sunday, please, are you still with us?
Yes, sir.
Okay, please, you can
Yes, I'm
start your
still with us.
presentation.
I want to share the slide.
Yeah, start the presentation before the slides come up. Thank you.
Okay. So in our group, we discussed intellectual property in relation to engineering, the tech industry, and also the tech industry, the pharmaceutical industry, and also the engineering industry. So I want to start with the engineering industry. The engineering industry, intellectual property essentially refers to the concept, creation, procedure, or approach that an engineer creates. And we have example of that. We have example of that. We have technical requirements, we have designs, we have system processes, and we have system processes. These are the examples of intellectual property in relation to engineering field. And also I'll be moving to the types of intellectual property that is relevant to engineering industry. We have the patent, and we have the trademarks and copyright. I hope you are all hearing me.
Yes, we can hear you. Yes, we can hear you. Please go ahead.
Please, I'm coming. So, as I was saying, we have patents, which is the exclusive right for inventions and processes. We have trademarks, protection for branding and distribution goods. So trademarks is majorly for distribution of one product or a product of an enterprise from another enterprise. And we have copyright, which is for safeguarding the expression of ideas and information. So I'll be moving to why should engineers protect intellectual property. It is necessary for engineers to protect their intellectual property because it preserves exclusivity. It also prevents replication or misuse. If you are not authorized to use intellectual property of an engineer, you won't be able to use because it prevents replication or misuse. It also helps in financial remuneration and also competitive advantage. And the last that we have here is capital position. So it helps market position. It helps the engineer to be able to market their intellectual work. I will be moving to illustrative examples of intellectual property in engineering. Patent help in the engineer in patent help in engineering to it help empower sufficient power efficient electronic circuit also. And also trademark is as I've earlier said, trademark is a unique logo of an enterprise. Trademark is used to distinguish or differentiate a product from another, and the relevance to engineering field is to distinguish a company logo or sign from another company. We have also copyright, the blueprints of an architectural model. Copyright in engineering field is a blueprint of an architectural model. So I'll be moving on to intellectual property application in diverse engineering field. We have civil engineering. So the unique bridge constructed by civil engineering can have a unique structure, that need to be protected, and that's the reason why intellectual property is important in engineering field. We have also biomedical engineering. We have biomedical engineer, and we have biomedical engineer, which also is intellectual property help in biomedical engineering to. I'm coming, please. I'm having problem with my network to be able to share the slide so that others can see. I'll be moving on to proprietary software and trade secrets. So in engineering field, it's intellectual property help to secure and protect confidential information by the help of trade secrets. I'll be moving on to role of intellectual property protection in IT and communication advancement. IT and communication industry, intellectual property is relevant in IT and information technology because it helps to protect in order to continue advancement and encourage even more innovation. It helps to protect and also to encourage intellectual protection for communication related to ICT. We have trademarks, we have patents, and their contribution to innovation. Importance of intellectual property in ICT. Intellectual property helps in ICT industry to protect intangible assets. It also helps in safeguarding confidential information. It also helps in maintaining uniqueness of inventions. It also helps to maintain a competitive edge. So in ICT industry, intellectual property helps to maintain a competitive advantage or edge over other industry. So we have case example of industry that ignore intellectual property protection in the communication industry. We have the case of BlackBerry versus NTP. NTP sued BlackBerry for patent infringement related to wireless email technology. Despite initially losing the case, BlackBerry faced the risk of a court-ordered shutdown of its services. To avoid this, BlackBerry settled the case for $612.5 million, highlighting the financial and operational risk of not protecting intellectual property. So BlackBerry in this case faced the risk of not protecting intellectual property. I will be moving on to intellectual property in the medical and pharmaceutical industry. It is largely recognized that pharmaceutical industry rights are essential for the continued innovation and new medicine, and therefore exist in the interest of patients and society at large. So pharmaceutical industry exists in the interest of patients and the society at large, and intellectual property is very important in that industry because in producing medicine it takes a lot of time, it's a risky, lengthy and expensive invention, and that is why it needs to be protected. So I'll be moving on to types of intellectual property protection in pharmaceutical companies. We have trademarks, we have trade secrets, we have copyright and patent. Patent is one of the most recognizable intellectual property right in pharmaceutical industry because it's an invention. A patent provides its owner the exclusive right to prevent others from making, using, offering for sale, selling, or importing the patented invention without the owner's permission. So the relevance in a pharmaceutical industry is that patent rights are essential for the continued innovation of new medicine and therefore exist in the interest of patients and society. So it helps to encourage innovation of new medicine or drugs. I'll be moving on to importance of intellectual property in the pharmaceutical industry. It safeguards medical innovation. It propels competition and economic growth. It helps in economic growth of a nation, and it also protects customer and investors' trust. It allows in tackling solutions for worldwide health challenges. It imposed bans on infringers. We have case here, we have case examples for pharmaceutical companies that gained revenue for protecting their intellectual property. We have the case of Johnson and Johnson. The case of Johnson and Johnson has successfully protected trademarks for Johnson has successfully protected trademarks for a wide range of pharmaceuticals and medical devices, including Tylenol and Band-Aid, allowing the company to maintain brand recognition and consumer trust, leading to sustained revenue growth. So this case, the case of Johnson and Johnson is a case that a pharmaceutical industry gained from protecting their intellectual property. We also have a case here of a company that lost revenue for not protecting their intellectual property. We have the case of Pizza. A legal battle ensued to protect the brand against generic versions of their drug products entering the market, with lawsuit filed for patent infringement. Despite legal efforts, Pizza market share for these drugs declined, but the company continued to innovate and develop new medications. So this company lost for not protecting their intellectual property. I'll be moving to intellectual property in the tech industry. In all areas of invention, tech include healthcare, communications, and even agriculture. There's need for inventors and companies owning inventions to take stock of and ensure proper management of the intellectual property. So the tech industry need to take stock and ensure proper management of their intellectual assets. We have advantage of intellectual property protection for tech inventors, competitive advantage and market leadership. It gives tech inventor competitive advantage and market leadership, revenue generation through licensing and sales. So a tech industry can license their intellectual assets or property for revenue, and they can also sell it to be able to acquire, to be able to get revenue. It also helps in bargaining power in corporate deals in case of merger and acquisition. So in merger and acquisition, intellectual property help tech industry to be able to have bargaining power in corporate deals, encouragement of further innovation. Intellectual property in tech industry help to encourage further innovation. We have a case here, case example of the tech industry that lost revenue from not protecting their intellectual property. We have Apple versus Masino. In this case, they had lawsuits over infringement on blood oxygen features. The U.S. International Trade Commission's ruling was in favor of Masino. The impact of Apple's revenue and export processing are greatly affected. So in this case, this case shows the effect of not protecting intellectual property. The plaintiff lost in this case for not protecting their intellectual property. So I'll be rounding up now. In conclusion, intellectual property is very important for invention in engineering, and also in engineering, in pharmaceutical industry, and also in tech industry, because it helps to protect their invention and also prevent others from using them without authorization or permission through the use of trademarks, patents, and copyright. So this is our presentations, and thank you all.
Thank you very much, Mr. Sunday, for helping us run through that presentation. Thank you to all the group members that contributed in helping helping the presentation go well. Thank you for your patience. We would like to take our mentors' feedback, but considering how fast spent we are on time, right, we would just like to go straight and take questions. We'd just like to go straight and ask questions. So please, do our mentees have questions to listen? So as we take questions, while our mentors answer those questions, they can also help us run through some feedbacks on the presentation. So please, can we have mentees ask questions for those who are still with us on call? I'm sure quite a number of us have network issues. I don't know what's been wrong with the network yesterday and today. It seems something seriously up with the network. But thank you all for your patience. Please, we would like to have questions from our mentees. Do we have questions to ask? Our mentors are still on call. I'm sure they are eager and ready to take our questions. So please, let's ask questions. Okay, it seems nobody has questions, but I think a question was sent to us by, okay, here's a question. A question here is, in case of international contracts for IP assets outside where they were registered, how do they insert clauses that prevent infringements there? Say, for example, licensing a copyright use outside Nigeria. So that's the question that I think Olusegun Philip Idowu is asking. Let me look through our mentors list. Okay, let me run it through the top. Ms. Shukurat, please, would you like to answer this question? And also, if it would be possible, can we get a little feedback from you as pertaining the presentation? Ms. Shukurat, are you with us?
Hi, Dennis. Oh, I think I lost you. Can you come again, please?
Okay, the question is, in case of international contracts for IP assets outside where they were registered, how do they insert clauses that prevent infringements there? Say, for example, licensing a copyright use outside Nigeria.
Okay, so like we all have mentioned, intellectual property is territorial in nature. So you can't actually use contract to protect yourself in a place where your IP is not registered. So while Liz was talking about contract, that is, in as much as you are trying to protect yourself with IP, you should also include some IP clauses in your contract. But you have to protect yourself first in that country. So if you are protected in Nigeria and probably you want to exploit your IP rights in some other countries, if you've not registered your IP or protected your IP in that particular country, you can't use contracts to protect it holistically. You can to some extent, maybe if there's a dispute, how do you want to settle the dispute and all? But you can't use contract to say, don't use my trademark when you haven't protected that trademark in that country. I don't know if that answers your question.
Thank you so much, Ms. Shukurat, for helping us with that question. All right, please, Ma, we also still want to hear from you about your feedbacks on the mentees presentation.
Okay, I think I wasn't around for a while because I had to prepare for what I'm going to use to break. But I think I once I listened to the group 1 presenter, and I also went through the presentation slide. But they all did well. But I think at some point she was kind of I think she kind of lost the difference between trademark, copyright, industrial design when it applies to fashion. So I think it's just that balance. You need to understand the aspect of trademark when it comes to fashion, the aspect of copyright, and the aspect of industrial design. Although you can use trademark to protect 3D designs, it might not really work well when it comes to a wearable material, right? It can work for objects like your 3D phone shape, your Coca-Cola bottle and the likes. When it comes to an industrial material that you're going to put on your body, you actually look at maybe industrial design as opposed to trademark, and maybe copyright in some jurisdiction, because some jurisdiction you can use copyright and industrial design to protect design, like wears in fashion. But in Nigeria, you use industrial design to protect a cloth that a fashion material that you've mass produced. Then you use copyright to protect the sketches or the artistic work. So you just need to understand the difference. Then for the second presenter, you spoke on patents and the engineers, but I didn't get to see where you spoke about industrial design, because as engineers will always come up with pilot plans. They'll come up with prototypes. So if your prototype has the element of industrial design, then you also have to go to the industrial design registration route to also protect the aesthetic aspect of that object, and not just the functionality and the technicality for patents. So that will be my contribution. Thank you.
Thank you so much, Ms. Shukurat, for helping us through with that question. I saw Mr. Charles. Please, you said you would like to ask a question. Please, you can go ahead and ask your question.
All right. Can you hear me, sir?
Yes, we can hear you.
Okay. My first question is, I have two questions. My first question is to Ms. Amusa Shukurat. Okay, I saw a release that she made on LinkedIn earlier today, and she was talking about prior publication, or when she made mention of, she illustrated like a distance of where Rihanna wore a shoe, and then she released it. She did a photo of it even before the fashion brand that she was representing released it and all of that, and then the fashion listing lost its case in regarding how to protect the distance. So I want to know like how everything revolves around that. And then two, my second question is in terms of trademark, right? That you did not register trademark doesn't necessarily mean that there's no defense for you, but just that when you have to actually go into a diligent work in order for you to win your case and all of that. So when a trademark is not registered, how do you defend it? What are the necessary things that you need to do? Is it maybe long usage of that trademark, or what are the necessary things that you need to like check out for if, for instance, you don't register a trademark but yet you still want to defend it?
Okay, thank you so much, Mr. Charles, for that question. So we would like to have Ms. Shukurat answer the first question, and then the second question will be referring it to Mr. Max to help us with that. So Ms. Shukurat, are you still with us?
Yes, I'm here with you.
Yes, ma'am, please. So can you please help us with the first question he asked about
I believe his first question was on disclosure, scenario. Right? Disclosure. Okay. So like I mentioned earlier, am I still with you? Can you hear me?
Yes, ma'am.
Okay. So like I mentioned
sorry, please,
earlier,
can you?
Every jurisdiction have their own law. You realize that in that material, I mentioned registered community design, right? And you wonder, do we have registered community design in Nigeria? No, we don't. But in the European Union or the EU IPO, they have registered community design and they have unregistered community design. Now, because EU is like a community of different countries, right? So you can decide to do a protection that covers you in those countries in the EU, just like we have ARIPO, we have OAPI, and we have EU IPO, right? So that kind of protection will protect, if you protect anything, if you register a patent in the EU, it's going to cover all those countries or all those states that are in the EU, because what they have is a unitary system, right? Then for Registered community design, it applies majorly to that jurisdiction. When it comes to Nigeria, we talk about industrial design. But like I said, when I was talking earlier, I said there's something common when it comes to patents, industrial design, and plant variety, and that is novelty. So what do we refer to as novelty? Novelty is a requirement that whatever it is we are doing has to be new. And new means that it must not have been disclosed, because the moment you disclose what you have done, it's going to invalidate your application. So disclosure is very important. Make sure you are not disclosing your invention before filing. So what, for example, if you are a researcher and you have a publication, you want to publish your journal, we advise that, okay, try as much as possible to file a patent first. Because if you publish before filing a patent, your publication can either invalidate or anticipate your application. And at the end of the day, it will be invalidated. You won't get your patent granted. So before you put your product out there, in as much as you want to see the market reaction or how people are going to like your product as well, you don't want to test the market. Now, there's something called grace period. Okay, so grace period is like, okay, fine. We understand that as a designer or as an inventor, you like to put your product out there and see how it's going to do in the market. So the Paris Convention says, okay, we'll give you like 12-month period from the day you put that invention out there. We give you 12-month period. Some countries do 6 months. Some countries do 12 months. So 12 months from when you put that product out, you have to file for application for protection. And some countries do 6 months. 6 months from when you put that invention or disclosure outside, you have to file for registration. Once you don't file within that 12 months or within that 6 months, and you don't file before you even disclose, then you can't get patent protection or design protection on something like that, because you've lost the opportunity. And this is where IP strategy comes in. So you want to like, which strategy should I use? Yes, I want to test the market. At the same time, I still want to get protection. Which IP strategy should I use? Should I file preliminary application? We call it, I can't remember now. There's a name for it. Before you file, you want to do like test the waters. You have another 12-month grace period before you can now file the main patent application. So you put in all those strategies and see which one is best for your product. Do you understand this? So basically, the general law is don't disclose before you file. But in a situation whereby you've disclosed before you file, then you have the option of grace period to cover you. But the downside is that not all jurisdictions have that grace period system. So if you put out your invention in a jurisdiction that doesn't have grace period, it means nothing is going to cover you. But in the EU, they have grace period system for 12 months. And if you read that publication, you will see that Rihanna had published that material, or she has won that shoe 12 months after. She has won that shoe and is now trying to file application 12 months after, which is supposed to be from when she wore that shoe, 12 months interval to file the application. I don't know if you understand it.
Yes, ma. Thank you very much, ma.
Okay, you're welcome.
Okay, thank you very much, Ms. Shukurat, for helping us answer that question. I think the second part of the question you asked about, I asked about
trademark.
Yes, about trademark. Mr. Please go ahead, continue.
Yeah, I asked about that a trademark is not registered, right? Does not necessarily mean that it cannot actually have a defense or something. So I was now saying is that in a situation whereby there's an unregistered trademark and you want to go and look for the defenses and all of that, to me now, I might assume that maybe a long usage of it might amount to a defense. Maybe you not register your trademark, but people already know it in the market that this is popular here, this is popular here. Would that amount to a defense if there's an unregistered trademark, or if it does not, what actually amounts to where a situation where you can defend an unregistered trademark?
Okay, thank you very much for rephrasing the question. Mr. Marks, please, can you help us with that question, the answer to that question, sir?
Okay, thank you. So sorry if I got the question right. The issue is that somebody has a trade or a mark that he uses to put his product in the market but has not registered it, and there's an infringement and he wants to recover remedy. Is that correct?
Yes, sir, something
Did I
like
get the
that.
question right?
Or maybe
Yeah.
or maybe another person has gone ahead to like
To register
use
it.
it. Yes, yes,
Okay.
and something like that. Yes.
Okay. Okay, thank you. Yeah, so the first thing to note, and maybe this is just a general comment on IP rights. You need to understand that the different IP rights have different issues surrounding registration. Note, first of all, that copyright does not need registration for protection to happen. The moment you have created that artistic or that creative work, sorry, and you have fixed it in a medium, automatically you are protected. However, in Nigeria, for instance, we have the voluntary deposit scheme with the Nigerian Copyright Commission where you can voluntarily deposit a copy. What that voluntary scheme deposit does for you is that it helps you establish the date of at least earliest publication of the work. So if two people are contesting a particular work of copyright work, and one person is able to produce the certificate of voluntary deposit from 2012, and the other produces a certificate from 2014, it will go a long way in persuading the court that the person with the certificate from 2012 actually came, was the first person to produce that work. So with copyright, you don't have to register before you get protection. With trademark, you may not need to register. You can still get protection, and I'll explain that. But getting registered gives you enhanced protection, and I'll also explain that. But when we get to the last region, and Amosa had mentioned that, just to be clear, that with patents and with designs, you must register. No registration of patents and designs, no protection. So it's just good to understand that spectrum from copyright, where you don't need registration, to trademark, where registration may not be necessary, to patents and designs, where it is absolutely necessary. So with copyright, if your copyright is not registered, you can still get protection under the common law called passing off. Passing off is an action in tort where you are able to persuade the court that that mark or that name or that unique brand, you have invested a lot in it and you have created such a goodwill that automatically everybody associates that mark with your product. Therefore, the defendant is now using that mark or that name or that brand to pass off, to present to people as if the product is coming from you, and by that he's taking in benefits from the goodwill that you have created. But however, it's difficult to prove. So if you have a registered trademark, you don't have to prove goodwill and all of that. The moment you have a registered trademark and the other person infringes that trademark, automatically you get damages from the court. But with passing off, before you get damages, you must prove that you have created goodwill, people have associated that brand with your products, and that the other person actually knowingly appropriated that brand and is trying to steal your goodwill. But with trademark, it's not a matter of whether the person is aware of a trademark or not. The moment he uses a trademark a mark that infringes on your trademark, registered trademark, automatically he's liable in penalties. But it's an interesting aspect to that question you asked, which is quite a complex issue. Where you already have a mark that you have invested so long in, and you have gained distinctiveness, that means people in the market have associated that mark with your products, or you never registered the trademark, and somebody else goes behind your back and tries to register that trademark. The Trademark Act in Nigeria, at least, gives you a right at the point of opposition to oppose that trademark and show that you have had prior use of that trademark, to an extent before the other person is trying to register. And if you can show also that the other person has not put that mark into any use, or likely doesn't look like he intends to use that mark, then that also becomes strong evidence on your part to get the registry to prevent him from registering that trademark. So, but to avoid all of this, it is always wiser to register a trademark as soon as you can, so that you don't fall into that space where you are trying to either use the law of passing off, or you are trying to fight off somebody else who's registering a trademark. But sometimes you might not know when the trademark was published and it's already been issued. And then suddenly you now realize that somebody else is in the market using your exact mark, and then you have to now go to court to set aside proceedings, which of course can be quite complicated and difficult. So of course, to spare yourself all of that trouble, registering your trademark as soon as possible remains the best policy. Thank you.
All right, thank you very much, sir.
Thank you so much, Mr. Marks, for helping us answer that question. We have Jess. Jess, you're raising up your hand. Please go ahead and ask your question.
All right. Thank you. I hope you're getting me.
Yes, we can hear you loud and clear.
All right. So I'm going to be very fast. I have two questions, right? The first one had to do with this, our Africa, you know. If you had a look at our continent, there are many challenging countries that are still suffering, especially when it comes to the protecting of someone RDS. But I want to know in the light of this, wherein, you know, as a result of this, will you come up with those ideas in order for those ideas to be protected in some of these challenging countries? There's an increased cost, most especially in my country. You will have something like an increased cost before you get copyright to your own work, or maybe like a patent with a new idea. So I want for our mentors to, you know, tell us regarding what some of those things you have determined. For example, what are some of those things I should be able to look up to before, in order to make sure that my ideas are able, or can, or those ideas are meant to gain intellectual property protection. And the second one had to do with uh one of our mentors from, I think, Kenya, was like talking about wherein a few students writing a thesis, they came about with a new idea, but because they were all blind to it and it wasn't protected. So I don't know whether you have, like our mentors have already taught on this, like being able to help some of our brothers and sisters that are out there who most of the time they get those crafted ideas, but because they don't have the means of protecting those ideas, they don't even have the knowledge on it. Other people will see them doing it, and as a result of that, take those ideas and make it their own.
Okay, thank you, Jess, for your question. Okay, I think one of the questions was directed to Miss Liz, right? So, Miss Liz, can you just help us run through the two questions Jess asked? I think if I got Jess right, he asked how countries that have like a bit of challenge, how can people protect their IP? But let's say as a result of high cost for registration. I think if I got him correct, right? And I think I can't really recall the second question, but Miss Liz, did you hear his question, ma? Miss Liz, are you still with us? Okay, Miss Liz seems to not be with us at the moment. Okay, I think Miss Regina is still with us. Miss Regina, are you with us, ma? Okay, it seems our mentors are currently not are indisposed. So I'll still want to direct that question to Miss Shukrat. Miss Shukrat, please, do you have anything to say on the question that was asked by Jess?
If I get his question correctly, I think he's asking about the criteria. What criteria do you have to look out for before you can actually get your IP protected? So each of the elements of this IP, they have different criteria. For example, when it comes to copyright, your copyrighted work has to be original and fixed. That is, you have to have put in some amount of originality to show that, yes, this is your idea. It's not a copy and paste. You didn't copy it from somebody, and you've not just changed color yellow to color blue and say this is original to you. You have to have put in some measures to show that, yes, this thing is original to me. And number two, it has to be fixed. I think the first speaker mentioned something like that when they were presenting. So with regards to copyright, originality and fixation, those are the requirements. Your work has to be original. That is, it's not the idea in your head that will be protected. You have to express that idea. And by expressing that idea, you show your originality. So it is the expression of the idea that is protected. not the idea in your head. So if you have been asked to write a brief write-up on what you learned in the Jiipcc mentorship program today on IP for creative and inventors, we all have the idea of what we discussed there, right? It's just that the way I'm going to write mine will be different from the way Oga Max is going to write his. So it is that expression that is being protected, not the idea. And for you to have copyright over a work, it has to be original and fixed. So that is the requirement for copyright. For patents, it has to be new, inventive, and industrially applicable. For industrial design, it has to be new and it should not violate public morality. For trademark, it has to be distinctive. And by distinctive, I mean it should not be descriptive, it should not be deceptive, it should not be generic, and it should not violate public morality. So all of these IP have their own criteria. The criteria for trademark will not work for patents. So you have to know what exactly it is that you have. And by so doing, you first have to identify this your idea. Okay, yes, I've identified this my idea, and I've come to see that it is about writing of books. Then you look out for which IP protects writing of book. Then you say, okay, fine, copyright. What is the criteria for copyright to succeed in a work? Then you see originality and fixation. Do you understand? Does that answer your question? So you have to be very intentional about what you are doing. Then for the second aspect of your question, I think you asked about how can people or the community help students with their ideas so it doesn't get stolen. Now, in some cases, when it comes to employer-employee, university cases, it's always said like whatever it is you do as an employer or whatever IP you create in the process of that's your job application or your studentship in that university, whatever you create belongs to the university or the institute or whoever it is your employee is, right? But as a student, if you've created something, or maybe you invented something, for sure you must have used the university's material to do your invention. Probably you make use of their data, you make use of their lab, you did one or two things with the university material. So because of this, some laws will tell you that your IP rights, yes, it belongs to you. You are the inventor, but the university is the statutory inventor. That is, they are the one that own it. What you did is just like authorship. Okay, so it depends on the law of the jurisdiction. Some laws on jurisdiction will tell you that, okay, yes, you own it, but you have to like write in agreement to transfer your ownership to the university or to your employer. Some will tell you, yes, you and your employer can, find a balance. You both can own it and you both can exploit it. So it depends on the law of the jurisdiction. But in most cases, as a student, your university owns the IP. So to back this up, there's supposed to be an IP policy that expatiates how this IP right is being owned, used, or commercialized. And what benefits is the student getting as an inventor? So as it's supposed to be, if you invent something as a student in a university or institute, your name as the inventor should be on the patent application, such that when they now commercialize that invention, a particular amount of money will get to you as royalty for being an inventor on that invention. But the ownership will actually go to the university or your employer and so on and so forth. I hope that answer your question.
Yes,
Okay,
thank you.
thank you very much, Ms. Shukrat, for helping us run through with Jess's question. Okay, I can't seem to find the remaining, the question that was asked on the chat box. Okay, here's the question. I think this is the last question we'll be taking for today before we call it a close. Okay, and the question is, are there sectors where IP thrive better than others? And how can we tailor this knowledge to help people for this sector understand the value in their business? Are there sectors where IP thrive better than others? And how can we tailor this knowledge to help people from this sector understand the value of IP in their businesses? So, okay, Miss Liz, if you are still with us, I would like you to just help us with this last question before we go.
All right, thank you for that. So I think I'd answer it this way. Every business that we know is a, is success because a success because of a carefully crafted IP strategy, because IP is everywhere, right? So it's more about how does a business strategize to be successful than which industry is successful or which area is more successful. You'll find that it will depend. If you have a good strategy, then you will thrive. So I'll give an example. When it comes to film, just look at the strategy that Harry Potter has taken as an asset, yeah, between the publishers and the author. Their opportunities for royalties and revenue is so wide because of how far they cast their net. They turned elements from the book into trademarks. And then with the trademarks, they went into merchandising. Like, they did quite a lot. So it's really about strategy. If you look at even pharmaceutical companies, you will find that some companies do well than others because of what's it called? Because of the IP strategy, basically, because of what kind of drugs they make, right? The guys who are like SmithKline Beecham is one of the most successful companies because of the brands that it is known for and how it markets them. They do a lot of the what should I say? Acidic, if you have like a stomach problems, they have the meds, like indigestion and whatnot. The kind of marketing they do for that, like Actol terms and whatnot, is really huge. When it comes to, I think Panadol is one of theirs as well. It's always about the strategy. And you see with IP is once you identify the strengths and the weaknesses of the IP regimes that surround the various IP assets that you create, then you're able to handle yourself better. You're able to have strategies that support whatever weaknesses that you may be aware of. Like, for example, how copyright is very, how should I say? Copyright can be very malleable. It's 1 minute it's strong on this side, it can be weak on this other side in a different aspect. So once you identify, you realize, okay, I'll need also contracts, because with contracts, I'll be able to ensure there is no circumvention. No one will try and do a similar show like me, especially, member of the crew. I'm able to sign a non-disclosure agreement because I went and presented a program concept of some sorts, and I'm aware that doesn't fit in the traditional mechanisms of IP, but it has a proprietary value, so I need a non-disclosure agreement. So it's literally about the strategies. So you'll find that the companies or inventors or inventions that will do well, it all comes down to the strategy that they have more than anything. It's never about which industry is better than the other. It's literally about strategies. That's why when you look at even the software space and startups, it's one of those spaces that has been deemed to be very lucrative, but it's literally about the strategies that different companies will take. The reason why Facebook, also now known as Meta, is strong compared to some of the companies that they even came and left, is because of the IP strategy. It's about how they've been reinventing in the space, how they are keeping up with modern times. Before you couldn't play any music on Facebook, now they do that. Now they're monetizing and they're paying artists, all these things. So that's what I'll say. It literally comes down to the strategy, understanding the strengths and weaknesses, and making sure that you complement the weaknesses with whatever ways that are required, like contracts, to secure to strengthen basically your intellectual property. That's how I'll answer that. Thank you.
Okay, thank you very much, Ms. Liz, for helping us with that question. Okay, we are fast spent on our time, and I sincerely want to apologize to all our mentors for how far short we had to go on time. But I'm sure everything that we have all our mentors have shared into this class has been what's the weight and what's the stay. So because of the so much information, I it skipped my mind for us to take our picture section much earlier on, but I don't think that still stops us, right? We can still have our picture session. So please, I would like to employ our mentees, and if our mentors too, if it would be possible for them to also turn on their video cameras if they have lighting in their settings or where they currently are, so that we can just have a quick picture time, and then we can draw the session to a close. Okay, do we have mentees who can turn on their videos so that we can run through that very quick and then go off onto this session? All right, my own location is very dark, so sorry about that. I can't turn on my own video. Okay, thank you very much. We are done with that. I've taken the picture. Thank you to our mentors and thank you to our mentees for complying. I really want to say a big thank you to everyone who was able to stay through to the end of the session. It has been a wonderful time. So full of wisdom in that sense, if I will put it that way, right? There has just been so much knowledge shared. And I'm sure that our mentees were really paying attention. I hope they were really paying attention. I also noticed that quite a number of people were having difficulties with their networks, also with me. So I would kindly like to ask for you guys to just go over to our YouTube page and just revisit this class so that you can redigest, right? If there were parts you probably missed out of during the section, you can just visit and then reconnect, take down the necessary notes you need to take, revisit as many times as you can, so that you can just have that at the back of your mind, and I'm sure it will be very helpful. I once again want to say thank you to our mentors, to Miss Liz, to Mr. Max, to Miss Shukurat, to Miss Regina, and then to Miss Zerona, all in absentia, right? Thank you so much for your time. Thank you for your patience with us, and also choosing to constantly do this, always coming back to share your wisdom, your knowledge, right? We are truly, truly, truly grateful. And I think with that, we've come to the end of today's session. It has been a wonderful, wonderful time, right? We look forward to seeing all our mentees in the next class, and also our mentors also in all subsequent sessions and subsequent quarters. Thank you very much, and do all have a lovely evening, everyone.